So, what are the constitutional provisions of the executive branch of government? California's executive branch is set forth in Article 5 of the California State Constitution and is obviously one of the three branches of state government, just like there are similar three branches at the federal level. The major distinction between the two is, of course, the state is headed by the governor, while the federal government is headed by the president. And in both instances, they serve as the chief executive. The following are the key provisions of Article 5 of the state constitution that deal with the executive branch of government. Section 1 vests the executive power in the governor. Section 2 provides that the governor is elected every 4 years and must be a United States citizen as well as a resident of California for the past 5 years. Section 3 requires the governor to report to the legislature each year on the condition of the state, which we refer to as the State of the State speech. Section 4 provides that the governor can require officers and agencies to furnish information related to their official duties. Section 5 of Article 5 allows the governor to fill a constitutional office vacancy by appointment, and that appointee is subject to confirmation by both the state assembly and state senate. Section 6 authorizes a statute to allow the governor to reorganize functions among the state agencies, other than those that relate to the other constitutional offices. And these measures are known as Governor's Reorganization Plans, or GRPs. Section 7 provides that the governor is the commander in chief of the militia and may call upon the militia to execute the laws of the state. Section 8 provides the governor with authority to grant reprieves, pardons, and commutations, except in the case of an impeachment. Section 9 requires the lieutenant governor to have the same qualifications as the governor does. And Section 9 says that the lieutenant governor is the president of the Senate, but whose only official role is to cast the deciding vote when there's a 20-20 tie. Section 10 of Article 5 provides that the lieutenant governor will become governor when a vacancy occurs in the office. In addition, Section 10 says that the lieutenant governor shall act as the governor during an impeachment of the governor, when the governor is out of state, or when the governor has some sort of temporary disability. Section 11 provides that the lieutenant governor, the attorney general, the controller, the secretary of state, and the treasurer of California are all elected at the same time as the governor is elected, and they're all limited to 2 terms in office. Section 13 provides that the attorney general is the chief law enforcement officer of the state, and that it's the attorney general's duty to uniformly and adequately enforce the laws of the state of California. And then finally, Section 14 prohibits any state officer from knowingly receiving any salary or wages or any other sort of earned income from either a lobbyist or a lobbying firm. In addition, Section 14 prohibits all state officers from accepting any honorarium, and the legislature is required to enact laws that either ban or strictly limit the acceptance of a gift that might create a conflict of interest for any of these state officers. And then finally, the legislature, pursuant to Section 14 of Article 5, is required to enact laws that prohibit state officers, agency secretaries, and department directors from lobbying the executive branch of state government for 12 months after they leave office.